thank you for joining us today. My name is Yongki Hwang, and I'm a senior associate at Scott Legal PC. Today's webinar will focus on the rules and requirements of a National Interest Waiver. We are very fortunate to have our firm's senior associate Jiyae Hwang as today's speaker. She is widely recognized for her expertise in NIW matters and has a strong reputation among immigration attorneys. She has also spoken on NIW at several immigration lawyer conferences, so we truly have a great opportunity today to learn from her insight and experience. Before we dive in, let me briefly introduce our firm and go over a few housekeeping items. We are a full-service immigration law firm, and we offer services in a wide range of areas, including E2, O1, TN, H1B, and any types of employment or family-based green card cases. That said, our firm is especially well known for our work on National Interest Waiver cases. We have built a strong reputation in this area, and over the years we have handled many of those cases, including quite complex and challenging ones. And we have successfully secured approvals in the vast majority of them. At the end of this webinar, we'll send you several useful tools. A copy of the PowerPoint presentation we'll go through today, a link where you could download the guidelines with more details on visa options, a link to sign up for the additional webinars, a link to the webinar recording on YouTube. We encourage you to subscribe and hit the notification button as we regularly post immigration related videos. And lastly, a link where you can set up a private consultation with our team. Finally, for any questions, please type them into chat box or the Q&A box. We'll address all the questions at the end of presentation. And with that, let's get started.
All right. Thank you very much, Yongki, for the introduction. So let's quickly go over the general basics of what is an NIW, right? So the NIW is short for National Interest Waiver, as many of you may already know, and it is a subset of the EB2 employment-based immigrant petition category. And when we say immigrant petition, this means this is an application for a green card for U.S. permanent resident status. And as many of you may already know, a green card gives somebody the ability to live permanently in the United States and work for any employer. And having a green card also opens up the pathway to U.S. citizenship in the future. Now, the EB2 NIW is a popular choice among individuals who want to apply for a green card on their own without a U.S. sponsor, U.S. employer sponsor, and this is called self-petitioning, which means you can apply as an individual, whereas normally you would need a U.S. company to sponsor you for a green card for employment. Now, the EB1A extraordinary ability petition is another category that allows self-petitioning. However, EB2 NIW is very popular because compared to the EB1A, the EB2 NIW is a little bit more versatile and can be viable for a wider variety of professionals in various stages of their career, even if they cannot show that they are the top 1% of their profession, who can show that their work will make contributions, significant contributions to the U.S. industry or society or their respective fields. Now, the green card option that can be available, the NIW can be applied for when the government concludes that you are coming to the United States to do something that is in the national interest. And we'll go into a little bit more detail on what exactly that means and what tests the government uses to define national interest. And as I mentioned a little before, the NIW is a subset of the EB2 employment-based green card category, but because it is a special category, it has a much higher bar than the perm process, which is the ordinary labor certification requirement-based process. If when you have a U.S. company sponsoring you and the U.S. company is giving you a job offer. The EB2 NIW, if you can qualify under that program, you don't need to show a job offer. However, because it is a special exemption, you do need to show meet additional criteria, a higher bar than the usual approach. So the NIW is adjudicated under a three-part requirement test based on a recent AAO case from 2016. It is called Matter of Dhanasar. And in addition to meeting the three-prong test of Matter of Dhanasar, you must also show that you meet the EB2 threshold requirement, which can be met by either showing that you have an advanced degree or a bachelor's degree plus 5 years of post-baccalaureate progressive work experience in the profession or exceptional ability in the sciences, arts, or business. And this threshold requirement doesn't just apply to NIW cases, but all cases under the EB2 category, even cases where you do have a US company and are being sponsored through the PERM program. And we can go back to the first slide and I'll go over the other bullets. So as I mentioned before, you do not need an employer to apply for a national interest waiver, which makes the NIW a very attractive and coveted category. And the waiver does relate to the EB2 requirement that you must prove that the ordinary EB2 requirement that a U.S. company ordinarily needs to prove that they cannot find a qualified U.S. worker, which is the PERM requirement. And the challenge for the NIW is proving why your case merits an exemption from the ordinary requirements of a job offer and labor certification because your case is in the national interest. And one important note that I do want to emphasize before moving on to the next slide is that applicants in any field can apply using the EB2 NIW pathway. It is not true that it is limited to only STEM fields. We've had approvals for many entrepreneurs in various fields, ranging from graphic design to satellite technology, to even lawyers who were working on several innovative projects that were advancing the field as a whole. So really what's important is what are you doing in the field and what will be the impact of your particular project to the field, as opposed to what is your field. So it is definitely not true that only STEM professionals can apply. And even if you are working in a very attractive industry, such as AI or cybersecurity, just by saying that you'll be working in an important field will not suffice to meet the NIW requirements. You also need to convince the government of what the impact of your work will be within the field of cybersecurity, within the field of AI. So really, what is your field is not the important question. The important question is what are you doing in the field and what will be the prospective impact of your work in your field. All right, so we can move on. So as I mentioned earlier, the EB2 threshold requirement must be met, and this is a common requirement for both PERM and NIW cases. Advanced degree, master's or higher, so PhD, for example, and degrees such as an MD, a medical doctor, also counts as an advanced degree. JD, Juris Doctor for lawyers, it also counts as an advanced degree. And if you are meeting the threshold requirement with a bachelor's degree plus 5 years of post-baccalaureate progressive work experience, you do need to make sure that you are providing enough information about how your job duties changed over time within the 5 years. So that's what we mean when we say progressive. The government is looking for evidence that your job duties and responsibilities changed in complexity, increased in complexity and seniority and responsibility over time. And if the evidence shows that you were only doing the same duties over the 5 years, unfortunately, that will not be enough to meet the progressive work experience requirements. So definitely pay attention there. If you don't have a degree, if you don't have a bachelor's, or if you don't have the work experience, or if you don't have the master's degree, you can also meet the EB2 threshold by showing that you have exceptional ability in the sciences, arts, or business. And one thing to note is that exceptional ability is not extraordinary ability. You only need to show that you are working at a level that is above what is significantly above what is ordinarily encountered in the field. You do not need to show that you're one of the top few percent who have reached the top of the field. And in order to show that you have exceptional ability, there is a list of criteria that you can mix and match to prove this. You must be able to show at least 3 out of the 7 enumerated criteria here. And this includes things like any diploma or degree, even if it's not a bachelor's or a master's. If you have 10 years of full-time work experience in your occupation, if you have a license, if you command a high salary, if you can show that you've earned recognition for your achievements and significant contributions to your field by your peers, government entities, or professional or business organizations. There can be a great variety of types of evidences you can show to potentially show that you have exceptional abilities. So even if you do not have the required degree or work experience, definitely this is another area you can explore on how to meet the EB2 threshold. All right, so now we'll move on to the next slide. So let's go into a little bit more detail on what are the NIW requirements. And the NIW eligibility requirements is really laid out under this case Matter of Dhanasar with a three-prong test. And it is important to note that you need to meet all 3 prongs in order to qualify for the NIW. So let's take a look at the first prong first. Applicant's proposed endeavor has substantial merit and national importance. Let's dig a little deeper on what that means. So step 1 in the NIW process is really to clearly define the endeavor. And it is important to note here that you must present a specific project or goal that goes beyond simply working in an occupation. So as I mentioned before, even if you're working as an engineer in a very attractive industry such as AI or cybersecurity, if your proposed endeavor is just a one-line proposal saying that I am an engineer and I will work for Google, for example, as an engineer, that is just limited to simply planning to work in an occupation. And unfortunately, the government does not consider that that is enough for a concrete proposed endeavor. By contrast, if you have a specific project that you can share with the government, a research project that you're doing, for example, within the field of AI engineering, maybe you are working on developing a new specific training approach or a new model of, building a data set or things like that, something more specific, something more targeted. And if you can explain how that is advancing the general practice in AI science. So let's say the whole field of AI engineering is limited because of, this particular limitation on how this data set is built. And maybe you're, developing new technology that will significantly improve this problem for the field as a whole. And maybe you will share this technology once it is developed through, conference presentations. Maybe you will author a patent regarding this technology, and maybe others will be able to license this patent or cite to this patent and cite it in their own research. Or maybe you will write academic articles regarding this new technology that you're developing, and maybe you will publish it in academic journals and share this research with other experts that way. So in that way, you could prove to the government that your work will have a larger impact to advancing technologies in the field. And that is really the type of endeavor that it has a more attractive pull in meeting the first NIW requirement. Now, a couple of other things to note regarding national importance. Geographic scope is no longer the focus after Matter of Dhanasar, so you do not need to necessarily show that your work will be touching every single state in all areas of the United States, as long as you can show that it will have a broad impact in your field as a whole. So endeavors that have national or even global implications within a particular field, such as improving manufacturing processes, resulting in medical advances, improving treatments for particular diseases, for example. It doesn't tend to just be limited to one particular region, because if you develop a new cure for a difficult disease, then other doctors will want to also try your new treatment. So that will qualify as a, global or national implications in that particular field. Or if you can show that your work will result in substantial positive economic impacts, that can be found to have national importance. If you are trying to prove that the economic impacts of your work will be substantially positive, then it really needs to be a large scale economic benefit that we're talking about. Just, creating just a dozen jobs, a handful of jobs in a particular region, for example, may not actually be enough of a large scale to count as a substantial positive economic effect in the current adjudicatory environment. So really the important thing to note is that the expected benefit of your work would go beyond your immediate employer or your immediate clients. So if you're just, adapting, pieces of code for the benefit of one particular company, such as you're an AI engineer for Google and you're just serving Google's interest and only helping Google's bottom line, even if the employer is a large employer, unfortunately, in the current adjudicatory environment, the government takes the position that that is not enough to meet the national importance requirement. There must be a broader impact to the field in terms of, the examples that we talked about before, such as improving manufacturing processes, medical advances, things like that, things that are analogous to that kind of impact. So really, when we talk about national importance, we focus on the larger scale and broader impact of the endeavor to really change the status quo of what is going on in the field, in a way that is advancing the field more broadly. Two more points to make before moving on. There's been, several misconceptions about this, but just the fact that there is a job shortage in the United States for a particular occupation, that does not mean that the profession rises to the level of national importance. So, for example, the U.S. may have a shortage of pilots. However, that argument on its own will not support a viable argument for national importance, because the government will simply come back and say, well, if there is a job shortage in the population of pilots, then the labor certification is the right pathway for a US company to hire foreign pilots. The NIW is not that way. So really, this is not a viable argument, and it is very clear that this will not work. So relying on job shortage is a very risky argument to make when you are preparing an NIW case. In another way, the nature of the proposed endeavor is also very important when you're formulating the explanation of what you will be doing. So in Matter of Dhanasar, we see that endeavors such as teaching is discussed by the government as a type of endeavor that only tends to benefit the immediate students who are receiving the teaching. And the government takes the position that such endeavors, such as teaching, unfortunately does not rise to the level of national importance because the impact is locally limited. It is only limited to the people, the direct students of who benefit from that teaching. So, for example, if you're a professor and if you are preparing an NIW argument, in order to meet the national importance requirement, not only should you talk about teaching, but really the national importance could be better served, argument could be better served if you have a different argument for impact, such as maybe through research. If you are, engaging in research and development as a professor, and if you are publishing your research to other experts and influencing other researchers, their own research in that way, that can be a better argument to meet national importance than focusing on the teaching activities that you may do. So definitely a nuanced approach is quite recommended and necessary in arguing the national importance argument. All right, so we'll move on to the next slide. Yeah, so now let's go through the second and third requirements under Matter of Dhanasar. So the second prong requirement is that the applicant must be able to show that they are well positioned to advance the proposed endeavor. And here, the focus is not necessarily on the impact of the endeavor itself, but really on the individual who is applying. And so the applicant must show that they have the required expertise, the experience, and a record of success that will make it likely that the person will successfully drive forward this endeavor and really make an impact in the field, as we looked at in the previous slide. So, several elements that the government will look at. The government will look at the person's background, including the education, credentials, and work experience that is relevant to the proposed endeavor. Really, the government is looking for a track record of success and influence in the field. So you may want to develop a portfolio of your previous projects that were most impactful and provide evidence of how this was impactful. So if you're a researcher and if you published, journal articles, then you provide a copy of the article, and you also provide copies of other articles that were citing your article, which can show that your article was influential on impacting other research. So that is one way to show previous, record of success and influence. If you're an entrepreneur and if you were the CEO of a very famous startup that was later acquired for millions and millions of dollars, you can provide evidence regarding that. You can provide, media articles and press releases talking about this significant acquisition. You can provide evidence of what the company was known for, what were the kind of innovations that the company offer to the field. You can build that, body of evidence to show that you had that record of success as an entrepreneur. So really, the evidence that we would collect and present depends on your field. And really, there is no one way you can argue a record of success and influence. So definitely, I recommend working with a lawyer who can really explore the, intricacies of your own field and how best you can, formulate and present such evidence. Now, if you have published patents before, if you're somebody who's involved in R&D, if you've published intellectual property, if you've, licensed a particular solution to other companies and you can show licensing contracts, for example, to evidence that, those are some ways you can show that you had influenced the field that can be very helpful in this prong. How far along is the endeavor? Evidence of traction, interest from U.S. institutions, and contracts with U.S. Industry actors can be very helpful. If you are already in the United States, maybe in an E2 visa or O1 visa, for example, if you're already running a business project, if you can show this objective evidence of traction, I've if you're working on an EAD even, and maybe you already, founded the company and maybe you've gained admission to prestigious accelerators or incubators. Maybe, it was backed by Y Combinator or Techstars, things like that. Like those kinds of evidences of industry traction can be very, very helpful in showing that you're well positioned to advance the endeavor because you have already made that progress to date. Similarly, if you've been running the company maybe on an E2 visa, and if you have experienced significant growth for the past several years, and if you can show tax returns showing a growth in revenues, if you can show Forms W-2 showing that you already hire a high number of employees, those types of evidences can also be very helpful in meeting the well-positioned prong. So really the strategy of arguing well-positions depends on what are the particular facts of each case, and the best presentation of the evidence can really differ. But there can be a variety of ways you can argue this prong. Now, let's move on to the third and last prong, which is the petitioner must be able to show that on balance, it will be beneficial to the United States to waive the requirements of a job offer and thus of a labor certifications. So you can rely really on any of the evidences you already used for prong one or prong two to support this prong, because it is really a balancing test. You can even bring in some evidence relating to your extraordinary ability if you have, judged the work of others in the field, if you've, been presented with awards. You can bring in evidences like that and try to prove that, really your work cannot be easily replaced by just another U.S. worker with minimum credentials. So some of the evidence you used in prong two, for example, a record of success, if you can show that this record is really unique and the expertise that you bring in that particular niche is so unique that it will not, be easy to find another US worker with minimum credentials to be able to replicate your work. That can be one way you can successfully argue the third prong. In the case of entrepreneurs, there are also several special arguments you can make in favor of your case. So you can use the fact that entrepreneurs are self-employed and often not eligible for green cards under the traditional labor certification program, because many of you may already own a majority interest in your company, which makes it more difficult to go through the perm process. Entrepreneurs can also use the fact that it will be impractical or impossible for them to obtain the green card through the labor certification process, which is the argument I just mentioned, to show that on balance, it will be beneficial to waive the labor certification requirement just because this category is really not practically applicable to entrepreneurs. However, it must be noted that all three prongs must be met for a successful NIW case to go forward. Just meeting the third prong would not be enough. So if you're an entrepreneur case, not only do you need to meet prong 3, but you also already should have been able to prove that your work does not tend to just benefit your own company or your immediate clients, but will have a broader impact to the field, to the nation, to the industry, or to your particular niche. So really, to summarize, Dhanasar does specifically note that entrepreneurial work can lead to an NIW and states that the planned venture does not need to ultimately succeed as long as the applicant can show it is possible that it will succeed. But keep in mind that all three Dhanasar requirements must be met in order for the case to go forward. All right, so we'll move on to the next slide. Okay, so now let's go into a little bit more detail about national importance, which in many cases becomes a linchpin of a successful case, and in recent years have been getting a lot more scrutiny than before on this prong, particularly national importance. And understandably, for entrepreneurs, national importance can be a very tricky thing to prove because you need to show in what way the benefits of your work go beyond providing good services to your direct clients or direct customers, but is going to impact the field more broadly. That can be difficult to meet for applicants in industry, which, as opposed to applicants in academia, for example, who typically do more publication and public-facing research dissemination activities as part of their job. So let's look a little bit on how national importance is adjudicated in recent years. Right. So in order to prove that your proposed endeavor will have national importance, you need to prove the importance of your specific proposed endeavor, not the importance of the field or occupation that you will be working in. And we've already spoke about this in previous slides. Expert letters can be very important in supporting a national importance argument because the government wants very targeted evidence of what the impact of your project will be. They don't want to just rely on general articles talking about the importance of the AI field as a whole, for example, or general articles talking about the importance of cybersecurity to the nation. The government doesn't want to rely on those general reports because those reports are not focused on the impact of your particular project to the field. So expert letters can help fill this gap because if you can get letters from experts, maybe independent experts who are active in the industry, to talk about what are the specific limitations that your niche is facing and talk about your proposed project and really give the explanation of how your proposed project will improve this problem for the field as a whole. So really the experts can provide that narrative in a way that other general reports and general articles cannot. So expert letters can help to fill that gap. Now, as I mentioned multiple times before, benefits to one specific employer alone will usually not be enough to meet this national importance requirement. The government is looking for broader impacts to a field, a region, or the public at large. So let's look at a few examples. And this is from the USCIS policy manual, which was revised in 2025. For example, a person developing a drug for a pharmaceutical company may establish national importance by demonstrating the prospective public health benefits of the drug to the public as a whole, instead of solely projecting the profits that will accrue to the employer. So here, the government is looking at what is the broad impact to the public welfare, public benefit, as opposed to, looking at how this endeavor will help the bottom line of that particular employer who the person will be working for. So, and this really shows that even if you're working for a particular company, right, or even if you will be working for a particular company, if the benefit of that of the work that you'll be doing is only limited to, economic benefits to that particular employer itself, that will not be enough. But if the impact will also have a public benefit that can improve the lives of many people, that can be a different kind of argument. And this example with the pharmaceutical company really illustrates that on how you should frame your argument. Now, another way to prove national importance is if you can show a widespread interest within the field in adopting or licensing a technology that you will be developing. If you will be developing a novel and important manufacturing process, or if you can show how the technology that you're developing stands to impact the development of similar technology by other companies. So let's say if you're working in a very cutting edge field, in a cutting edge competitive industry, and let's say you were the one who developed the industry's first foldable phone. If you do that for Samsung, for example, it is very likely that Apple or Huawei or other companies will also try to, emulate that and also try to, release their own foldable phones. So those types of examples can be a way to show that if your work stands to influence the development of similar technology by other companies, then it could be a matter that can be found to have national importance, as opposed to just tending to benefit the bottom line of a particular employer. And it is really a kind of a nuanced argument that you're making here, a nuanced distinction, because, one endeavor can have many different benefits, but really it is about choosing which areas to focus on when you're presenting your national importance argument. And for that, really the advice of experienced counsel can be critical and really make or break your case. Finally, substantial economic benefit. Creation of U.S. jobs at a level significant with respect to a population or economy of a region can support a national importance argument, but in the recent previous years, the way that the government interprets what is substantial in the benefit has really risen up. So if you're only creating a handful of jobs, a dozen jobs, for example, and if your revenues tend to be sort of the typical small business revenue scale, then unfortunately that in itself would likely not be enough to be considered as support for national importance. The government is looking for a larger scale benefit. And here in the 2025 policy manual edits, the USCIS added this phrase, significant with respect to a population or economy of a region. So there is that comparative aspect, especially if you're working in an economically depressed region, you really want to focus on that region and how much of the, population of that region will be affected by your, significant investment endeavor or things like that. That can be a viable argument, but only if the impact will be very significant. And it would be much recommended to get, a local government agency to confirm that this benefit will actually be significant with respect to the circumstances of that region. All right, so we'll move on to the next slide. So now let's shift gears a little bit and talk about some of the technical details on how a national interest waiver petition is prepared. So what is included in an NIW submission? So the first category of things that you would include with respect to evidence is proof that you meet the EB2 threshold requirement. Either you can meet the threshold requirement through showing that you have an advanced degree, master's or above, or if you have a bachelor's degree in your field and 5 years of progressive work experience following your bachelor's degree, you can meet the EB2 threshold. In that case, you would show the copy of the degree, a copy of the transcripts, and if your degree is from a foreign institution. If your degree is from a non-US university, it is very, very important to get what is called a US education equivalency report, which confirms that the level of, your foreign degree is equivalent to that level as judged under the US standards. And it is very important to get that evaluation because sometimes there is a mismatch. And if there is a mismatch, you need to think of other ways to meet the EB2 threshold because you cannot use that degree. So it is a very important technical thing to note when you're preparing a petition. When you try to prove 5 years of progressive work experience, I mentioned this in the previous slides, but you do need an employment confirmation letter from your previous employer, not only confirming how long you work there, but also the details about how your job duties changed over time to include more senior duties, to include more complex responsibilities. So getting that letter directly from your previous employer is a very important aspect of document preparation. Uh, if you are meeting the EB2 threshold through showing exceptional ability, you must provide evidence that you meet at least 3 out of the 7 enumerated criteria. So let's say if you're using any diploma or degree, for example, you will provide the evidence of the degree. If you're showing 10 years of full-time work experience, for example, you will collect the employment confirmation letters from previous employers that add up to 10 years of full-time work experience in your profession. And you should also be able to show that it's all of that is related to your proposed endeavor. So a little bit of work is needed to collect those evidences. So you do need to collect at least 3 out of the 7 and be able to present that. This evidence shows that you are somebody who is working at a level that is significantly above what is ordinarily encountered in the field. Now, meeting the EB2 threshold is only the beginning. The main challenge in presenting an NIW case is collecting and presenting evidence that you meet the 3 National Interest Waiver requirements as laid out by Matter of Dhanasar, national importance, well-positioned, and on balance. We've been talking about this in previous slides. So you can combine, mix and match a variety of forms of evidence. There is really no hard and fast rule, or there is really no formula on what kinds of evidence is helpful. It really depends on what point you are trying to prove. So let's look at a couple of examples. News articles, academic papers, market research, relevant data and statistics, and comprehensive business plan for entrepreneurs, government reports, and other objective evidence can be used to demonstrate that your proposed endeavor has substantial merit and national importance. Now, if you're using government reports or if you're using general industry articles, it is very important to combine that with targeted expert letters that talk about the prospective impact of your specific project. Because many of these news articles and government reports may not mention you by name. They may not be talking about your specific project. And if not, you can't just rely on these general reports about the field or the importance of the field or things like that. Those types of evidences are now regularly dismissed by USCIS. So really, it is important to ask yourself, like, what am I trying to prove? Am I trying to prove that my specific project will have this particular impact? In that case, what is the evidence I can provide? Do we have news articles talking about my project specifically? So maybe you founded a startup, and maybe when you got, when you raised significant venture capital for that particular startup, maybe it was reported, maybe your particular business was reported in industry media. Maybe there were press releases about your particular offering. Maybe, it was mentioned in places like Bloomberg or, Forbes or other types of major media. You can definitely use those types of media articles to support your claim of national importance and substantial merit. So really, it depends on what is the body of evidence that you have and how do we link that with what you are trying to prove. And that strategy can definitely differ based on what the facts are. Let's see. So we talked about the expert letters. some of the expert letters can also prove that you're well positioned to advance the endeavor. So if you're trying to provide more detail about your previous projects and how they were already impactful to the field in support of well positioned, when you're trying to build that record of success, you can use experts that you've worked together in the past to provide more detail with that narrative. So expert letters can be used to support both and either of national importance prong or the well-positioned prong. Your degrees, resume, proof of professional accomplishments. Again, as I mentioned before, if you had awards, patents, presentations, industry or media recognitions, those types of industry recognition evidence can be used either to support, national importance if it's related to your ongoing and current project or future project, or it can be used to support well positioned if those types of recognitions are related to your previous projects. Entrepreneurs. In the case of entrepreneurs, you can include proof of contracts, letters of intent, and startup capital to show that your business is ongoing and that there is traction within the U.S. industry to show that you're well positioned to advance the endeavor. And with regards to prong 3, you would likely just point to evidence that you've already used in support of prong 1 and 2. If you have extraordinary ability, types of evidence such as judging the work of others or awards or things like that, high salary, you can consider adding them here as well. But really, the important thing to note in preparing a national interest waiver package is that there is really no hard and fast rule or formula on how these packages look. Really, the important work to be done here is coming up with the right presentation to highlight the strongest points in a person's case, and really maximizing the persuasive power of what we're trying to prove. If we're trying to prove national importance, we want to make sure that there is enough objective evidence supporting that. If we want to prove well positioned, we also want to make sure that there is enough evidence of what you've been doing in the past and how they were impactful. So definitely, we will be happy to advise you in more detail if you schedule a consultation or want to open a case with us. All right, so let's discuss a little bit about recent trends and strategies. And I don't know if many of you have been following the changes in approval rates of national interest waiver cases over the past year, but now the Q4 of 2025, fiscal year 2025 had just been released a few weeks ago, and the general global approval rates for EB2 NIWs has now fallen to 36%, which is quite surprising. It is really the lowest point that it has gotten since we've been seeing data starting from 2018. It started from 90% in 2018 for EB2 NIW approval rates, and by Q3 of fiscal year 2025, the approval rate fell to 53%, and the most recent quarterly data, Q4 of 2024, we see that it has hit 36%, which means more cases are being denied than they are being approved, which is quite extraordinary. And I do think that a part of that is explained by the explosive increase in the number of filings that the NIW category has been seeing since 2018. So in fiscal year 2018, we've only seen about 8,000 cases a year being filed, but this has increased by fiscal year 2025 to more than 60,000 cases. So a five-fold increase from what we've been seeing, back in 2018, 2019, 2020. So with this increase, definitely RFVs and denials have also increased. And the government has actually recently issued policy guidance in 2025, and I've mentioned a couple of aspects about this in previous slides, that has clarified several aspects of what the government will look at when they are adjudicating NIW petitions in terms of criteria such as national importance and well-positioned. Now, with the new administration, we haven't seen too much of a drastic change in terms of the policy that's being applied. So I would say the guidance um, published in January 2025 is still pretty much the rubric that we are seeing in terms of how these cases are being adjudicated. This may change. So the definition of how national importance is, interpreted at any given time, really does change over time. So really it is important to get in touch with a lawyer who is current with all of these trend changes and can advise you of what arguments could work, what arguments have a likelihood of succeeding, and what arguments would be risky and may prompt a denial given the most recent trends. And let's talk a little bit about entrepreneur-specific strategies, which can be used. And entrepreneur cases are still being approved. It's just maybe a little bit more difficult than before. I would say 2023, 2022, there were a lot of entrepreneur cases being approved very quickly. But this has definitely toughened in terms of the adjudicatory environment. But still, entrepreneur cases are still being approved, and we have still been successfully securing approvals. So it is not impossible. Um, can require some creative strategy. So, for example, when you're trying to argue substantial merit or national importance, you can collect evidence such as significant media attention on the petitioner, the business, or both, awards or grants that you have received from relevant government entities, letters from third-party industry actors, from government agencies. Government agency letters can be very, very helpful, and we've seen several cases that were tougher type of cases, but were approved when they were accompanied by a direct letter of support from a government representative. So that can be a very useful strategy for entrepreneurs. Evidence of revenue generation, growth, job creation must be very significant and can be a stronger case if they are focused on revitalizing a economically depressed area, but the scale of this impact must be demonstrably large. Dissemination of results of an endeavor, such as research and development activity through conferences, patents, licensing, etc. That can be very helpful in meeting the national importance prong. If you can show that not only will your work just benefit your client's immediate clientele, but you will be publishing intellectual property or research articles or research insights that can be used by other experts as well throughout your field. Well position can be supported by evidences such as proof of ownership and critical role in the U.S. entity that you are running, degree certifications, letters describing of investment interest, of government grants, record of having published intellectual property before, either by the applicant or the company. So you don't need to be the inventor. The company can also be the holder of the patent. Any media attention regarding any of your previous projects, history of revenue growth, and those types of entrepreneur-specific evidences can help make the well-positioned argument. Okay, now we'll move on to the next slide. So there are some strategic considerations to be careful of when you're considering filing an EB to NIW petition. So timing is one consideration. So how long does it take to, obtain an approval for an I-140? So I think since 2023 now, premium processing is available for the I-140 portion of an EB to NIW petition for immigrant classification. This means an action on the I-140 will be rendered in 45 business days. At some point, it used to be 45 calendar days, but now it is 45 business days. So you do want to think about at least taking 2 months to get the response. But still, this is much faster than regular processing, which is currently taking over a year to get the initial response. And it could be an RFE, a request for evidence, in which case you would take many more months to, prepare the response to the RFE. And after that, another few months will take before the government provides you with the decision. So definitely premium processing is popular and widely used in getting, filing the I-140, underlying I-140 for EB2 and NIW. Note that the US green card process has two steps. So the first step is filing the I-140, which, proves eligibility for the green card. And the second step is the green card application itself. So let's say you're already in the US on a different type of visa, such as an E2, H-1B, what have you. Filing the I-140 proves to the government that you can apply to get a green card. And there are two options for you to actually apply for the green card in the second step. Either you apply through your home country consulate. So you apply for an immigrant visa and you travel abroad to get the immigrant visa and then come back in as a green card holder, or you file what is called an adjustment of status application, an I-485. If you're already in the United States in a valid non-immigrant status, you can file the I-485. And it is important to note that this second step, the green card processing step, also takes time. We would approximately a 1 year process to actually, get the green card after you file this second step application. So not only do you need to think about the time that takes to file the I-140 and get the decision on the I-140, but there is also time to think about of the actual green card application itself. So in all of this context, if you are on a non-immigrant visa status that does not allow for dual intent, such as a TN visa, for example, once you file the I-140, it may be more difficult to renew your non-immigrant visa. So you need to be careful about the timing of when you file your I-140. You may want to renew the TN visa first, for example, and then file the I-140. Definitely talk to your lawyer first if you are trying to figure out the best strategy for this. To mitigate those risks. So the application process is to first submit the form I-140 with proof that you meet the EB2 NIW qualifications. And if the priority date is current, you may be able to concurrently file a green card petition with the I-140, and that's a huge advantage. If the category is backlogged, you must wait until your priority dates become current before you can file an I-485. Historically, between 2022 and early 2026, the EB2 category has continuously been backlogged significantly. Now, very anomaly. It was an anomaly for, I believe it's for this month, April. I believe it's current for EB2, and it may have been also current in March as well. But yes, that is a huge anomaly. So if the visa bulletin displays current, that means you can indeed file a concurrent I-485, which reduces the overall timeline because you don't need to wait, before you move on to the second step. So definitely, the visa bulletin changes every month. So really, the ability to concurrently file the I-485 depends month to month on the particular set of facts. So check with your lawyer, check the visa bulletin before making the move. Because the costs of making the wrong move can be very significant. I've had a consultation with people who filed the I-485 when the visa bulletin was actually not current, and in that case, unfortunately, the whole case had to be denied. So, very costly mistake. It can be a very costly mistake if those technical details are not are not lining up the way it should. Um, Pros and cons of adjusting status in the United States versus consular processing. So, if you choose adjustment of status, it is important to note you may be stuck in the US for a while because while the I-485 is pending, before you have an advanced parole, you can't really travel abroad without abandoning the application. So, And advanced parole documents are taking a while to get approved. It can take many months, sometimes even close to a year. So there may be this, period of time where you're just basically stuck in the United States because the I-485, the adjustment of status application, unfortunately cannot be premium processed. So that's one consideration. Now, if you use consular processing, you have the freedom to, travel, I guess. So that is one advantage. But the disadvantage is that you need to independently maintain a separate non-immigrant status if you're planning to, continue living and working in the United States while this process is ongoing. And not all visas may be conducive to that. So definitely speak to your lawyer to see, what really are your options on you know, um, this step two process when you're applying for the green card. All right, so we'll move on to the next slide. So here is a case study of a successful NIW petition filed for um, a small business entrepreneur. I won't really go into too much detail about the case study. We're going to send you copies of the PowerPoint after this presentation is over, so you can read through this at your leisure. But yeah, this definitely is a good example of, how an entrepreneur can support the three prongs of a national interest waiver test. So it is worth perusing. All right, so now I think we'll move on to the next slide, and we're ready to answer some questions you may have.
Well, thank you, Jiyae. It was a wonderful presentations and very insightful. We learned a lot of things. We have one question. It's not directly related to the NIW issues. It's more like a public charge issues. So I suggest that uh, Mahmood, you probably want to contact us and set up the private consultation so that we can answer privately regarding the public charge issues.
All right. I don't think there are any other questions. Thank you so much, Yonggi, for hosting the panel. If no one has any other questions, maybe give or take 10 more seconds. Will my work experience be matched with my visitation log in the United States? Yeah, so um, I think this question is also related to when you're actually applying for the green card. For example, if you're, applying for an adjustment of status, they will look at your entire immigration history. So you do need to show that you've complied with all requirements. And if you haven't, you need to talk to your lawyer and talk about what strategies you can use on, how to explain any, any issues with that. So yeah, definitely you need to, show that you've complied with all the work authorization for any work experiences that you use either in the I-140 or I-485. Your work experiences would be disclosed, and the government has access to all of your papers. So if you said that you did something in the I-140, they will also be able to look at that when they're adjudicating your I-485. So everything should line up from the I-140 stage. That's definitely for important consideration, which is why, working with a lawyer from the beginning is a good idea, such that you can, proactively identify any issues and make sure that the papers are prepared the right way from the beginning. So definitely reach out to us for a consultation, and we'll be happy to discuss your private circumstances. All right. I don't think there are any other questions. So yeah, thank you everyone for your participation. Thank you, Yonggi, for hosting.
Thank you.